Good evening, everybody. My name's Sam King, and I'm introducing our speakers for this evening. So I want to welcome you to, sorry, can you, anybody who's not speaking, i.e. anyone who's not me, mute, please. I want to welcome you to this evening, which has been organised by the LGBTQ Forum within the auspices of Middle Temple. The LGBTQ+ Forum was created to support, advise and encourage members of the Honourable Society of Middle Temple and the bar in general who identify with under the broad heading LGBTQ+. Although the forum is described as being for those identifying as LGBTQ+, it's open to all and supportive of all. And we encourage participation by allies from every corner. We are inclusive and not exclusive. It's a particular pleasure to introduce everybody today because Master Treasurer, Master Hockhauser, is particularly interested in LGBTQ+ issues. And he is somebody who has taken a lead in relation to those matters within the Inn. I want to introduce our speakers in a moment, but just a couple of ground rules. The first is cameras on, because this is a qualifying session. So if you are hoping to qualify or use it as a qualifying session, then please keep your cameras on. Otherwise, there's no obligation to do so. There will be some questions at the end, so if you can feed those through, then we will deal with them in due course. And please remain muted throughout. I'm going to first of all introduce Stephen Liu, who's from Gardenport Chambers. He is recognised as a leader, as it were, junior in family law. He has been recognised by Chambers and Partners and the Legal 500 and is considered to be somebody who is conscientious, calm, authoritative and focused. And I'm sure that he'll bring all of those attributes to his talk this evening. He's the author of many articles on the area of family law. He's secretary of BLAG. He's a member of the committee within Middle Temple. And he's going to speak to you today in relation to the stark reality of LGBT law around the globe. I'm sure that he will provide us with an interesting insight into that subject. So if you would like to start, Stephen, we're all ears.
Thank you very much, Sam Kim QC. I want to be clear that it's important when considering the global legal framework that these are lived experiences of citizens of the world that go beyond the black letter law that will be somewhat of a sterile analysis of the relevant statute. For these people, there is literal blood, sweat and tears that accompanies many of the individual stories and the families of those LGBT people within the community. What needs to be understood is that the legal framework across the globe, certainly within about 70 jurisdictions, sits within a socio-religious and often post-colonial context linked directly to the UK. And this topic strikes a personal note for me, as I was born in Jamaica, where its LGBT citizens live in fear for their physical integrity on a day-to-day basis. The religious and political structures are disingenuously explained by saying that the murders of LGBT people sometimes come about as a result of jealous lovers committing acts of violence against one another, and the lives of LGBT+ people are described as an abomination. And I often think to myself, what my outcomes would have been if I was not born with dual citizenship and into a family with the socioeconomic means to raise me in the UK. This talk will not be an in-depth analysis of all 72 jurisdictions that criminalize private, same-sex, consensual sexual activity. All of them criminalize men and 44 criminalize women. It won't go into detail about the 11 jurisdictions that can or do impose the death penalty for same-sex intimacy. And it won't go into detail about the 35 Commonwealth jurisdictions which criminalize private same-sex consensual sexual activity. And again, this talk is not intended to reduce LGBT people to being defined by their sexual acts in the same way that straight people are not to be defined solely by what they do in the bedroom. This talk is a question mark in respect of those jurisdictions that criminalize private consensual behavior, and to draw parallels with all forms of discrimination against women, against ethnic minority communities, often Black communities, the Jewish community, and all forms of discrimination as a total waste of resources, and ultimately an act of irrationality demonstrating a lack of an intelligent analysis. And also on an ethical level, it is drawing a parallel with principles that are not grounded on the basic tenets of compassion, which is a far cry from the ethical standards that we as barristers seek to uphold. So it will be a broad brush to hopefully leave you in no doubt that whilst Pride in London has been complained about being a commercial event with a commercial edge, it still potentially has an important political force because it's based in advocating for the acknowledgement of human rights for LGBT citizens across the world. So I'll start with Jamaica. There has been an important and recent decision in the Inter-American Commission, which, interestingly, the Jamaican government has not accepted its jurisdiction, and therefore the decision is not legally binding. But what they have decided is that violence and discrimination against LGBTI people and the impact on buggery laws, they noted that the facts related to life, personal integrity, interference with private and family life, and that the discriminatory laws are obstacles to the right of residence and movement, unequal treatment. They provide a lack of access to justice and judicial protection, and they are an interference in an access to healthcare, which could establish possible violations of the American Convention on Human Rights. Now, the cases were brought by a man called Gareth Henry, who is a man living in exile, and a lady called Simone Edwards, who was a lesbian, forced to flee Jamaica, and they brought their applications against sections of the 1864 Offences Against the Persons Act. So they are Victorian laws brought in a colonial regime that are being challenged. So Simone Edwards was shot multiple times outside her home in 2008 by two men whom she actually went to school with. They also tried to kill her two brothers. One of her brothers was gay. And she said, I believe the gang members who almost killed me, they actually tried to shoot her in the vagina because their view was that as a lesbian, she had no use for her vagina. And so, as you can understand, the case is set against the backdrop of significant persecution of LGBT people in Jamaica. And so the Inter-American Commission finding was extremely encouraging, because their recommendations to the Jamaican government was that the Jamaican government repeal Section 76, Section 77 and 79 of the Offences Against the Person Acts, that they adopt an anti-discrimination legal framework to prohibit discrimination based on sexual orientation, gender identity or expression, real or perceived, and indeed body diversity. That they collect and analyze data on the prevalence and nature of violence and discrimination based on sexual orientation, gender identity or expression, real or perceived, and body diversity. Thirdly, that they apply due diligence in the prevention, investigation, punishment, and reparation of violence against LGBTI persons, whether in the family, community, or public sphere, and ensure that investigations are not permeated by prejudice. Fourthly, to conduct training, and this is the important one, conduct training for Jamaican public officials, particularly judges, prosecutors, public defenders, security officers, and the education, employment, and health sectors on sexual orientation, gender identity, and gender expression, body diversity, and the challenges faced by LGBTI people. Another key recommendation was that Jamaica engage with educational programs designed from a gender perspective in schools. And lastly, to deconstruct stereotypes and prejudices and include comprehensive sexuality educations in the school curriculum. However, I would add that this is something that we in the UK are also working on, and we have not yet got it right. So it's not just Jamaica that has been working with that issue, it's another jurisdiction as well. And at this stage, I would like to draw parallels between the recommendations of the Commission and the Wolfden Report in the UK in 1957. It was the Wolfden Report which led to legislative change in the UK, which meant that the LGBT community in the UK can now enjoy the rights that we do. So certainly I would argue that this is a process, and Jamaica is very much at the infancy of its journey. But again, to reiterate, the reason why I feel strongly that it's important that Britain's colonial history with Jamaica is held in clear focus is that the UK and its institutions, and I include Middle Temple in that, and all the other Inns of Court, they have a responsibility not to patronise former colonies in the Commonwealth, but to be part of a collaborative and healthy debate about what their current legal systems bring to the lives of their LGBT citizens. For instance, Jamaica is one of those countries that suffers from a phenomenon known as the brain drain. And if there was space for LGBT citizens to thrive, then perhaps the professionally qualified Jamaicans within the diaspora across the world would be motivated to go back and contribute to Jamaica taking its rightful place as the breadbasket of the Caribbean. However, the current legal and societal framework means that there is a massive waste of resources taking place in Jamaica at the moment. A key organisation involved with legislative reform across the globe is called the Human Dignity Trust. They are a fantastic legal charity, and effectively what they're doing is they're using the law and panels of expert lawyers from Freshfields and Silks in the UK and beyond to effectively challenge the legislative framework in various jurisdictions. And what they say is that anti-gay laws undermine human rights and perpetuate violence and discrimination. They particularly affect women and girls and LGBT people, and they undermine the health and prosperity of entire societies. And I'm going to go into further detail later on in my talk about why anti-gay laws impact on health and access to health, and indeed why money matters when it comes to LGBT rights. So the first stop on our world tour, in terms of a good news story, is Belize. So in Belize, there was a man called Mr. Oroso, excuse my pronunciation, who was a prominent human rights defender, and he successfully challenged Section 53 in the Supreme Court of Belize in 2010. And in 2016, the judgment was given by Chief Justice Benjamin, finding in favour of the appellant's grounds that Section 53 was unconstitutional, effectively decriminalising consensual same-sex activity conducted by adults in private. So that's a very positive story. But again, to reiterate, the criminalisation across the Commonwealth of same-sex sexual conduct in Belize is a legacy of British colonial rule. So as an example, a barrister, an English barrister called R.S. Wright, was tasked in 1870 with drafting a criminal code for Jamaica, and that code was used as a model for the Caribbean colonies, including Belize. Now, this hasn't just been a journey that the Commonwealth has been on. The EU has also sought the intervention of the Human Dignity Trust. And the example that I'm going to bring to you is the case of the Rad Van State Council, and it was a case brought against the Netherlands. And effectively, in 2013, the judgment as it pertained to 3 gay men, one from Sierra Leone, Senegal, and Uganda, the case found that 1, homosexuals form a particular social group for the purposes of the EU directive, and 2, sexual orientation is a characteristic so fundamental to a person's identity that the persons concerned cannot be required to renounce it. Therefore, an applicant for asylum cannot be expected to conceal his or her homosexuality or exercise restraint in the country of origin in order to avoid persecution. And what they found, thirdly, was that the criminalization of homosexual acts alone does not in itself constitute persecution. However, a term of imprisonment which is actually applied in practice in the country of origin does constitute persecution. Now, next on our world tour to Northern Cyprus. Northern Cyprus was the last jurisdiction in Europe that criminalized same-sex sexual activity between adults in private. And again, the criminal code was introduced in the island of Cyprus by British colonial authorities in 1928. However, on the 27th of January 2014, the Northern Cyprus Parliament, prompted in part by litigation brought by the Human Dignity Trust, passed legislation repealing the anti-homosexuality laws, effectively bringing the court proceedings to a conclusion. And that was a positive as a result of the legislation brought by HDT. Now to Singapore, which is an important case because it is at the forefront in terms of cutting edge, in terms of so many other areas of commerce and the law, and many Singaporeans come to the UK to study the bar. Homosexuality is illegal in Singapore. That's the nuts and the bolts of it. Singapore criminalizes all male homosexual intimacy, which derives from an amendment to the British Colonial Penal Code in 1938, which enacted Section 377A, which criminalizes, and I quote, male gross indecency, the penalty being a maximum sentence of 2 years imprisonment. It goes into further detail by saying that what is criminalized is carnal intercourse against the order of nature, capturing any sexual conduct, whether homosexual or heterosexual, that was not penile vaginal sex. There was a case brought in 2013 by a gay couple who had not been charged under Section 377A, but they felt that their rights were engaged and they were given leave to appeal whether or not it was constitutional. The judgment in 2014 is the final word on it thus far. The Supreme Court dismissed the appellant's appeals, and the court found that it cannot act as a mini legislature, and that equality before the law and equal protection of the law effectively do not protect LGBTI people, or indeed women, they said in their judgment in Singapore. Now, some of the background socioeconomic things going on is that Goldman Sachs in 2017 held a recruitment drive at a networking dinner for LGBT students at its office in Singapore. And the Minister for Social and Family Development said that foreign companies should not venture into public advocacy for causes that sow discord amongst Singaporeans. Disappointing. in December 2017, there was an edict from the National Council of Churches of Singapore, which reaffirmed their position, in case we were in any doubt, to say that the church does not condone homosexual practice and considers the homosexual lifestyle as sinful, and unacceptable, but added, homosexuals should be regarded and treated no less as persons of worth and dignity, which I thought was rather sweet of them. Good to know that we are people too. However, I want to end on a positive note in respect of Singapore, because in 2019, the Chief Justice said that the Section 377A is potentially not fit for purpose and non-constitutional. Moving on to the Seychelles have decriminalized homosexuality, which is a real positive. And I want to bring into focus the aspect of what role international business has to play in changing the international landscape in terms of legislative change. Because HCT have done research into this, and they found that the Ugandan president basically said words to the effect of, look, we can continue to engage with battles with the USA and the EU over how we treat gay people, but that is a small issue when you look at the big issue of our economic progress. And if our big issue of economic progress is going to be negatively impacted on how we treat our LGBT people, then we might need to consider conceding ground on how we treat our LGBT people, because frankly, it's the right financial decision to make. That leads to what I'm suggesting to you, which is that money talks and has an impact in how citizens are treated. So what is said is that international business are key players and stakeholders in civil societies. Businesses have the means to influence the debate on the treatment of LGBT people at home and abroad. Multinational corporations, they have direct access to governments and politicians in countries where homosexuality is a crime, and especially where most of the seed funding for those businesses comes from countries that have more liberal laws in relation to homosexuality. I would suggest that we as consumers in the UK and the US and Canada, we have an influence on what decisions those companies make when they go and do business in other jurisdictions that don't have laws that we support. It's also suggested, and I support, the premise that there is an economic case for decriminalization, because there's mounting evidence that decriminalizing homosexuality criminalizing homosexuality reduces productivity and economic growth. And that in and of itself is a reason to decriminalize homosexuality. But there are two aspects that I also want to highlight specifically. Sandals holidays used to be able to advertise on the tube. And then when sanctions effectively were put on them because they didn't welcome same-sex couples staying at their Caribbean resorts, it effectively meant that they were hit in the pocket. And what that meant was that when they were dropped by Barclaycard, Expedia, and the Tube, they had to change their policy, which meant that they now have company rules that make allowance for LGBT people. The other massive impact of criminalizing homosexuality on a global scale, and an argument for decriminalizing homosexuality, is that HIV globally and how it impacts on the LGBT community also then impacts on the resources of that country. Countries who don't have a lot of money to address citizens who are suffering with HIV, to pay for treatment and antiretrovirals, etc., it would make sense for them to reduce their citizens with HIV if they were to decriminalize homosexuality, because there is a direct correlation in those countries which criminalize homosexuality and those countries with the highest rate of HIV. And that is because structural factors such as stigma, discrimination and violence based on sexual orientation and your HIV status and gender identity all are impacted on by the criminalization of same-sex sexual practices. This contributes to hindering the availability and access and uptake of HIV prevention, because if by going to your local clinic, you're going to be outed, you're less likely to go get tested, one, and two, get treatment. So the Lancet report in July 2012 found that disparities in the prevalence of HIV infection in several African and Caribbean countries were directly correlated to the status of criminalization. I also want to spotlight on a global level how criminalizing same-sex acts impacts directly on women, because there are unique experiences in how the criminalization of homosexuality between women impact on women in a specific way that don't impact on men. And I express it in this way. Lesbians and bisexual women are criminalized in many jurisdictions around the world. They experience physical and sexual violence as a direct result, both of their sex and their sexual orientation. And they are kept under particularly tight control of their families and communities. And they have uniquely limited opportunities and safe spaces to express their identities. They are often marginalized within and outside of the LGBT community. And interestingly, within women's human rights movements. And there is a real experience of being excluded and not being on an equal footing in those local and global social and legal reforms. So one study in 2002 in Sierra Leone, where an activist called Fanny Ann set up an LGBT association in her country, and 4 men broke into the organization's office, they gang raped her and they stabbed her. Another study from the Asia-Pacific region described that violence against women is actually listed in court if it's pleaded that the women who suffered the violence were lesbians. It can legitimately be cited before the criminal court as a mitigating factor in the punishment of the perpetrator, therefore effectively sanctioning honor-based violence, because in many communities in the Asia Pacific, the family's reputation stems from the actions of the women. In Namibia, women are often threatened with corrective rape so as to cure them from being lesbians. And if lesbians try to go to the police in India, people have often been told that they asked for it and dockets go missing. And so I wanted to make sure to bring that to this discussion, because it's important that the lens through which this international discussion is being looked at is seen through not just the lens of gay men, but through the experiences of trans women and indeed lesbian women as well. So, the specific region in the Commonwealth, there are 11 countries that have overhauled sexual offences, and they've introduced new legal regimes that meet some good practices that can be applied. So good news stories come out of Australia, Fiji, Nauru, New Zealand, and Vanuatu. Some of those countries retain sexual offences laws that do not meet good practice and are outdated. But what is a positive is that in 6 countries, there are consensual same-sex activity. Forgive me, in these countries, it's a bad news story because it still criminalizes same-sex activity. That's Kiribati, Papua New Guinea, Samoa, the Solomon Islands, Tonga, and Tuvalu. I'm heading towards, I've got 4 more minutes, and I'm going to move now in my world tour to Asia. So in Asia, again, there are laws which are also impacted on by running common laws that run in parallel to Sharia law in respect of sexual offences. So that also has to be taken into account when looking at the legal framework. But in India, India is the only country where consensual same-sex sexual activity is no longer a crime, after the Indian Supreme Court found this to be unconstitutional in 2018. That is, of course, significant because India is one of the most populous countries in the world and is the world's largest democracy. However, it's a bad news story in relation to several countries that prescribe corporal punishment, for instance, whipping for sexual offences between two same-sex people. That is, for instance, Malaysia, and two countries that provide for the death penalty as a possible punishment for sexual assaults being Brunei and Malaysia. This is contrary to good practice. So that is the story in a broad brush approach with Asia. In again, a broad brush approach looking at Africa. In Africa, there are 19 countries that are former Commonwealth countries. The positive news story is that there are 6 countries which no longer criminalize consensual same-sex activity, and they are Botswana, Lesotho, Mozambique, Rwanda, the Seychelles, and South Africa. Of the remaining countries, many provide lengthy terms of imprisonment for such activity. So clearly there is a long way to go. And what I would add is that even in the UK, we have a long way to go in terms of the hearts and minds of society as a whole, as it pertains to LGBTI rights. Our current Prime Minister, in and of himself, has been on what can only be described as a journey in respect of his view of LGBT rights. He effectively had to be browbeaten into attending Pride, in contrast to Sadiq Khan, who was chomping at the bit to attend Pride, happy to do so, happy to take selfies, and that is a much better picture. So what I want to say is that after we have legislative equality across the globe, there is going to be generations and generations of work to do in respect of getting the hearts and minds across the globe to meet us where we would want them to be. And so after that brief world tour, the truth is that every country deserves its own talk. But given the time and the broad brush approach I wanted to take, that is the global picture, and I'm grateful to you for listening.
Thank you very much, Stephen. That was indeed a global tour and a bit of a whirlwind one at that. But thank you very much for all of the information that you gave us. I'm going to now introduce our next speaker, who's going to be speaking about gay life and law in 1980s Britain. And Simon is well known, like Stephen, within the family law network, as it were. I don't need a professional directory to tell me that Simon is a fabulously able advocate, because I've had the pleasure of being against him. And so I know firsthand. He is the energy behind the forum at Middle Temple. He is generally a very active member of the Inn, and he is something also of a TV and radio pundit. So many arrows to his bow. Simon, thank you very much. We're again all ears.
Good evening, everybody. It's a Sin aired on Channel 4 this year, written by Russell T Davies. It's set between 1981 and 1991 and is told over 5 episodes. It's the story of a group of friends, largely gay, who live in London in a house that they call the Pink Palace. It tells the story of 1980s from a very British perspective. And in that context, it also touches upon points of British queer legal history from that decade. Tonight, we're going to look at three main areas that are raised in that show in episodes 1, 3 and 4. There is one spoiler with regards to episode 3. So if you haven't watched that, I'm afraid you've been warned. But before I start, I'm conscious that a lot of you tonight are students and bar students who are currently desperately studying the law, trying to get to grips with the law as it stands and trying to keep on top of authorities as they come in. And you may be asking yourselves, why? Why would I want to listen to a talk about legal history? And why would I want to listen to a talk in particular about queer legal history from Britain in the 1980s? Well, there's a number of reasons that I would hope that you would want to listen to what I've got to say this evening, and not only because you're trying to get a qualifying session. The first reason is because a study of what took place in the past is the best way of understanding the laws that exist at the moment. Looking at legal history allows us to explore the quirks that exist today. It allows us to look at the etymology of injustices that continue to exist, but it also helps to cast a light on the pinch points that exist in the current state of the law. Queer legal history in particular is important, especially for those of us that are in the queer community. Where we stand in 2021 in terms of England and Wales owes a huge debt to those who came before us. And we've inherited a world where we've never had more rights in modern history. And we owe it, I believe, to look back and understand how we've got to where we are. Looking at the law as it was also allows us to identify patterns that can be used to project where we're going forward, but also to understand what has happened. Tonight, for example, we're only going to be looking at areas of criminal law, areas of public health, and areas of education and public policy. What does that in itself tell us? Well, that tells us that we're very much concerned in the 80s with the extent to which the state could curtail and interfere with the rights of individuals, in this case with the queer community, where it's often said that the Sexual Offences Act of '67 had been a step forward. The 1980s, in many regards, took a step back. Although the law now permits homosexuality in private by 1980, the state continued to condemn it in public. And that dichotomy of the public and the private is something that we will revisit throughout the talk. But just as an opening point, I would ask you all to consider the fact that gay rights, not only in this country, but also abroad, tend to be advanced by an original focus on conservative sensibilities, convincing people that the right to privacy and the right to freedom from state interference is a good thing. And that, in the initial stages, tends to be more successful than a focus, disappointingly, on equality and a celebration of diversity. In 1980s Britain, the establishment had an idea of what it was to be a respectable gay, someone who wished to live a heteronormative lifestyle, should be permitted to do so, but only if they did so in private. Because of that, none of the law that we look at tonight is about being gay in a public way. There wasn't a way to do that legally. We're not going to look at any family law, an area that all of the speakers tonight practice in, because the reality is that we would have to wait until the noughties before there was any significant legislation that advanced queer rights within a family context. The first primary example being the Adoption and Children Act of 2002, which permitted same-sex adoption by 2005, and of course the Civil Partnership Act 2004, which I imagine a lot more of you are familiar with. In the show, It's a Sin, tonight we're going to look at three of the characters, including Richie, including Colin and Ash. Of course, all the friends in It's a Sin arrive in London at the start of the 1980s. At that stage, London and indeed the rest of the cities in the country were enjoying the end of a decade where queer expression and queer visibility had never been higher. The 1970s had been a generally good decade. Gay Liberation Front had been formed at the start of the 70s, and the first gay pride protest had taken place in 1972. By 1976, a Monday evening club night called Bang with an exclamation mark had been held at the first time at the London Astoria, and that was a forerunner of what many of us now know as GAY. By 1978, we had adopted the first iteration of what would become the rainbow flag, which was designed by a man called Gilbert Baker over in San Francisco. Overall, at the 70s, things seemed to be getting better. But then things started to shift to the right. In 1979, Margaret Thatcher was elected Prime Minister of this country. The following November, Ronald Reagan was elected President of the United States. Regardless of where you stand on the political spectrum, you can't deny that there was a shift both in economics and in social policy towards conservatism. The 1980s, would be a time when those in power, both government, police, and indeed, sadly, in the judiciary, could express openly homophobic views, and they could do so without repercussion, and indeed they did. Just before we start looking at my first example from It's a Sin, we end the 1970s with a very high-profile case before the House of Lords. I'm not going to go into detail about it, but I would encourage those of you who are interested to read it. It was a private prosecution brought by the infamous Mary Whitehouse. She brought it under the blasphemy laws. This was in fact the first case brought under blasphemy laws in over 50 years. Gay News Limited had published a poem and a picture and were found guilty, both at first instance, and that was upheld on appeal, both in the Court of Appeal and then in the House of Lords. As I say, I'm not going to go into the ins and outs of the judgment, but the public failure of that case in terms of the gay rights movement perhaps sets the tone for what was about to come. In episode 1, which is set in 1981 and seems a good place to start, we find Richard Tozer, or Richie, played by Ollie Alexander, as a young lad moving from the Isle of Wight to London to start university. We can probably assume then, given his age, that he's probably supposed to be around 18 or 19. We also see him in the first episode engage in a large number of what we might now call casual hookups. The Sun was then to say, after the airing of that first episode, It's a Sin viewers shocked by drama's explicit sex montage with raunchy threesome and oral sex. Well, yes, It's a Sin did seem to contain a raunchy threesome and oral sex, but tonight I'm not going to be talking to you about the artistic merits of the show, rather to look at it in the legal context of the time. It's often assumed now that by the 1980s, gay sex in England was legal, following the 1967 Sexual Offences Act. But in fact, that probably needs, well, it does need to be questioned. As Robertson said in his book, Freedom, the Individual and the Law in 1993, homosexuality was not in fact legalised by the 1967 Act. It was merely permitted, and it was only permitted in private between two consenting males and only if aged 21 or over. To understand that, we have to go back and look at the Sexual Offences Act 1967 itself. That act states as follows: a homosexual act in private shall not be an offence, provided that the parties consent thereto and have attained the age of 21 years. The first thing to note about that act is that it's slightly odd from the perspective of criminal law drafting. It doesn't state something that is illegal, but rather clarifies something that isn't illegal. The purpose of that is, in essence, because anything that involved two men that was sexual and didn't fall within those limited conditions was still unlawful under the criminal law of England and Wales. What private meant, because it had to be in private to be lawful, was further defined in subsection 2. Private meant an act would not be considered private if it were done A, when more than two persons take part or are present, or B, in a lavatory. The first thing to note about this is that it only applied to men. English law has never criminalised sex between two women, certainly not within modern history. The next thing to note is that the age of consent was 21. That stands in contrast to heterosexual relations, which at least since that period has been set at 16. It was only reduced with regards to same-sex couples in 1994, and then only to 18. It wasn't put on a par with heterosexual age of consent at 16 until 2000. It's not the case, however, that people took this difference lying down. And in fact, in 1978, so just before the period that we're looking at, somebody had taken the British government to court before the European Commission in the case of X and UK. In that case, X was a 26-year-old man who'd had relations with two 18-year-old men. The Court of Appeal in this country seemed particularly perturbed at the 8-year age gap, noting that it was because of that age gap that they viewed him as a person who is a danger to the public. The question for the European Commission was whether or not the different age of consent for straight sex and gay sex was justified. Was it a justified interference with the right to private life under Article 8? The British government, in support of their position, which was that the law was right, argued that they argued in reliance upon the Wolfenden Committee. That report had recommended that the age of consent be 21 on the basis that it was necessary to protect young men from influences and pressures of an undesirable kind. The British government went on to state, on account of the social reprobation with which homosexuality is still frequently regarded, a minor involved in homosexual relationships with an adult might in fact be cut off from society and seriously affected in his psychological development. The Commission doesn't seem to have batted an eyelid at the suggestion that an 18-year-old may be psychologically harmed or his development impeded by a relationship with an older man. They did, however, comment that the UK was out of kilter with the rest of Europe, but otherwise dismissed the case as a justified interference in a democratic society for the protection of the rights of others, i.e. to protect young men from the corrupting influence of those who are older. It must be noted then that Richie is, of course, either 18 or 19 or around that age, as are his friends at university. And so, strictly speaking, under the letter of the law, none of them should have been engaging in any of the activity that you see. The law also, as I've already pointed out, made clear that an act had to be in private, and that as soon as there were more than two people present, it's no longer to be considered private and is therefore unlawful. So to go back to the Sun's comment of the raunchy threesome, that, of course, was not within the letter of the law at the time. Curiously, although it was legal for two men to go home and have sex in private, it wasn't legal for one man to invite another man home to have sex with him. And this curious dichotomy arises from an interpretation of the Sexual Offences Act of 1956, which had survived the 67 Act and maintained Section 32, which stated that it is an offence for a man persistently to solicit or importune in a public place for immoral purposes. One could be forgiven for thinking that because a homosexual act in private was now legal, it couldn't therefore be considered an immoral purpose for the purposes of conviction. Well, unfortunately, that is not what the Court of Appeal decided, much to the chagrin of Mr. James Gray, who came before the court in 1981. James was aged 30, and one evening in Earl's Court at about 11:30 in the evening, he was outside a pub when he saw a man standing across the road on his own. James crossed the road, said hello to the man, spoke to him for a little bit, and then invited him back to his flat for some whiskey. The prosecution's case was that James went one step further and also suggested that the man spend the night at his. Unfortunately for James Gray, the man in question was a plainclothes policeman who promptly arrested James. At trial, the defence, not unreasonably, was that upon seeing a man on his own, Mr. Gray had gone over to speak to the man and make sure that he was okay. He did offer him whiskey, but denied offering sex. At trial, an issue arose because of what the judge said to the jury. There was no question that the jury accepted the facts as set out by the prosecution, but the trial judge had directed the jury that as a matter of law, a homosexual act would be sufficient to be an immoral purpose. There was no dispute on that. In fact, the summary that is given to the jury is recorded in full in the judgment, and it goes like this. It is perfectly true to say, and I direct you in this way, that for two adult males to behave sexually in bed with each other in their bedroom is not an offence anymore. Members of the jury, you may think, although you have to be satisfied, it is a matter for you, that soliciting with strangers for an immoral purpose, it may not be an offence, but you may conclude in common sense, it is entirely a matter for you, that it is immoral. Well, the jury took that at face value and took it as a direction that a gay act was indeed immoral for the purposes of section 32. James was found guilty and sentenced to 9 months in prison, suspended for 2 years with a fine. On appeal, the Court of Appeal agreed that the question of whether or not a same-sex act could be an immoral purpose was not a question of law to be put to the jury, but a question of fact that should have been left to the jury to decide. Unfortunately, the court also went on to say that because the jury had effectively accepted the Crown's factual case, which wasn't in the end really denied by James, that the conviction was upheld, although they did quash the prison sentence. This is not the only example in the case reports of plainclothes officers arresting young gay men under section 32 and there being successful convictions. It didn't matter that the acts that they were proposing to undertake were now lawful. What mattered was that people still felt uncomfortable that they would talk about it in public. In reality, the extent to which gay men seem to have been concerned with the law seems questionable. Certainly, Russell T Davies has his character Richie say at the very end, "I had so much fun." And that does seem, in some regards, to have been gay life in the 1980s, which comes back to the dichotomy that I spoke about earlier. Because in an era when gay life continued to flourish in London in many regards, the police redoubled their efforts, in many ways appearing out of step with what was actually happening, and the law was falling quickly behind the times, particularly in Manchester, where there was a degree of state-sanctioned homophobia under the rule of the then Chief Constable James Anderton. For those of you not familiar with him, I would encourage you to look him up. But particularly interesting reports come from members of his own force who recall being ordered to stand in the rafters above public toilets, looking down at the cubicles, waiting to catch men trying to cottage. The criminal law then, as of the 1980s, was perhaps not as free and easy as one would have thought, having watched episode 1. Not that that appears to have stopped Richie. In episode 3, we now move forward to March of 1986. Before I talk about the legal point, some factual context for those of you who are unfamiliar with the period. In 1981, 5 young men in Los Angeles had died from a rare form of pneumonia. At that time, it was called by doctors gay-related immune deficiency, but the next year it would be renamed acquired immune deficiency syndrome, or as we now know it, AIDS. In 1982, Terence, or Terry Higgins, collapsed while at work in Heaven nightclub in London, not far from Middle Temple, and he died at St Thomas's Hospital not long after, again from a form of pneumonia. By 1983, it was generally understood in the medical community, that there was a virus and that it was infectious. There was still a huge degree of uncertainty about how infectious it was and how it could be spread. Dr. Anthony Fauci, who those of you who watched any of the Trump press conferences in the previous year or so will be familiar with, published an editorial, much to the upset of much of the queer community in America, in which he suggested that there was evidence pointing towards the ability for AIDS to spread through routine close contact. Yes, that was in America, but I flag it up because it shows the level of uncertainty that existed at the time. By the 23rd of April of 1984, the US government had announced with Drs. Gallo and Montenier that a virus had been identified as the probable cause of AIDS that we now know to be, or call HIV. By the end of that year, 108 confirmed AIDS cases had been recorded in this country, and there had been 46 deaths. In It's a Sin, in episode 3, we see one of the most popular characters, the adorable Colin, the Welshman, played by Callum Scott Howells, detained in a Welsh hospital. That aspect of the show has attracted some publicity and focus. Quite early on in the AIDS epidemic, the European Parliament had pressed on with adopting a resolution on rights for people with AIDS. But in doing so, they had stated clearly that the need for quarantine may be required. The resolution stated it may be necessary in certain well-defined circumstances to limit the rights of patients where they would involve a danger to the public. I ask you to remember that line, well-defined circumstances, when looking at what it was that the British government then did. Against a backdrop of relative inactivity and many would say indifference, the UK government took the first legislative acts in 1985 to exercise its powers under the Public Health Control of Diseases Act of 1984. It did so to introduce the Public Health Infectious Diseases Regulations of 1985. Those regulations introduced acquired immune deficiency syndrome, or AIDS, as a notifiable disease under the 1984 Act. What that meant is that if a medical practitioner diagnosed or suspected a diagnosis of AIDS, then he was obliged under the Act to inform the local authority, so your local council. For reference, other diseases included cholera and plague. But the regulations also extended the 1984 Act to cover AIDS in various other sections. Section 35 now allowed local authorities to apply for a person to be treated, to be medically treated by compulsion, where it was deemed to be in his interests or the interests of the public. Section 37 allowed for compulsory removal to hospital, and Section 38 now allowed for compulsory detention in hospital of somebody suspected to have AIDS. Those orders for detention could be made on the application of a local authority. They only required one magistrate, and they could be made without notice, i.e. without the person even knowing that the order was going to be made. There was no time limit on the period for which you could be detained, and any detention, once it had been ordered, could be easily extended as long as the magistrate was satisfied that it was necessary. But the regulations didn't stop there. The test for detention under the 1984 Act itself had been that a magistrate only had to be satisfied that the person would not, on leaving the hospital, be provided with lodging or accommodation in which proper precautions could be taken to prevent the spread of the disease. But that was extended under the regulations, so that now an order for detention could be made where a magistrate was satisfied that on his leaving the hospital, proper precautions to prevent the spread of that disease would not be taken by the person themselves, either in his lodging or in other places to which he may be expected to go if not in the hospital. That is much broader than the original drafting of the 84 Act. Now, there was speculation at the time, particularly within the medical community and some legal commentators, as to whether or not proper precautions and the failure to take proper precautions might actually extend to, for example, safe sex. If a magistrate was not satisfied that a gay man with HIV who had AIDS was going to take the proper precautions of using a condom, would that fit within the scope of the Act? Well, the simple answer to that is it would appear to be so, because the Act was so broadly drafted. There were questions then as to what would happen. Could hospitals be used as holding essentially prisons for people while waiting for treatment? The legal correspondent for the British Medical Journal identified that detention even seemed possible based on likely behaviour and the need for suspicion only, rather than on a balance of probability. So that's where the law stood. Certainly not quite what the European Parliament seems to have envisaged. But were there any Collins? Sadly, it appears that there was at least one. On the 14th September 1985, a magistrate ordered detention of a man, aged 29, in Manchester at Monsell Isolation Hospital for 3 weeks. The hearing at which that man was ordered to be detained was without notice. He wasn't present and he wasn't represented. It is said to have taken 5 minutes, and the magistrate concluded that his release would be, quote, very dangerous. The decision to detain him was made solely on the basis of evidence provided by the medical officer for Manchester City Council. With the assistance of the Terence Higgins Trust, the man in question exercised his right to appeal to the Crown Court, and 10 days after the original order was made, the case appeared before Mr. Justice Russell, sitting in the Crown Court at Manchester. Evidence was provided by the council from their officer, Dr. Anna Jones, who said that the patient had been bleeding copiously and trying to discharge himself. On appeal, however, counsel for the council accepted that the man's condition had improved substantially, and that as of the date of the appeal, the council could no longer justify his detention. This appears to have raised some judicial eyebrows, with a question to the council as to as to whether or not the man in question was still at a risk of contamination. What had changed? But the only thing that appears to have changed is that the man was now no longer saying that he intended to leave the hospital. The court allowed the appeal, but it did also say that the order in the first instance had been made on properly and that on the evidence available, and therefore opened the gate to further such detentions in other cases. The man in question, as I've said, was willing to remain at the hospital, which seems to have been one of the reasons why he was permitted, why the order was discharged. But that did lead to a Guardian headline at the time, which said, "AIDS man wins court but spurns freedom." The approach taken in this country did attract some academic commentary, both here and over the pond, and not positive. In 1985, two academics from the Library of Congress wrote, when comparing the US, Australia, and the UK's approach to the AIDS pandemic, "It is difficult to imagine a more intrusive regulatory scheme. Compulsory medical examinations based only on suspicion and compulsory hospital detention allowable without the individual being given an opportunity to be heard except to appeal a detention order. Where AIDS is concerned, the British apparently feel that the need to protect the public easily outweighs the individual's interest in freedom from government intervention." Now, "It's a Sin" definitely takes dramatic license, particularly in the scene where you see a barrister and a magistrate addressing the issue of Section 32. But in some regards, I do celebrate the fact that the series captures the seriousness of the use to which the Public Health Act can be used. Fortunately, such cases appear to have been limited in number, but there was at least one, and that was Colin. The importance of the Public Health Act is not to be forgotten, particularly for a point that I will raise at the very end. The last area that I'm going to cover with you tonight comes from episode 4, where we spring forward to March of 1988, where we see a teacher called Ash Mukherjee, played by Nathaniel Curtis. Ash, in his role as a teacher, is told to remove books from the library with references to homosexuality. The legislation that it is said that he's doing that because of, it was the Local Government Act of 1988. In order to understand that act, we need to know a little bit of what had been going on behind the scenes, or not, as the case may be. There had been a number of local government bills floated in Parliament over the course of the 1980s. And indeed, from the mid to late decade, there'd been a party political issue between Labour and the Conservatives about Labour councils providing funding to LGBT groups. By the general election of 1987, there were Conservative posters as part of the campaign claiming that Labour wanted LGBT books to be read out in schools. And by the Conservative Party conference in Blackpool in 1987, Mrs. Thatcher addressed the conference by saying this: "Children are being taught that they have an inalienable right to be gay. All of those children are being cheated of a sound start in life." The poster that I've referenced forms part of a theme that had been raised since 1983 to do with what books were in circulation in English and Welsh schools. In 1983, the Daily Mail had reported that a library in London had a copy of a book called Jenny Lives with Martin and Eric. Jenny Lives with Martin and Eric was a picture book depicting a day in the life of a girl in Denmark with her father and his partner, his same-sex partner. This book was held up both in the press and in Parliament, of an example of how the queer movement was invading the schools and children were being exposed to inappropriate literature. In fact, as the group Liberty would later report, only a single copy of that book, in fact, was held by any educational authority. It was held by a teachers' centre and had never been to a school because it had been ruled unavailable for any child to study. Section 28, sometimes known as Clause 28, was the Conservative response to this fear that they seem to have fanned. It inserted Section 2A into the Local Government Act of 1986, and it read as follows: a local authority shall not, A, intentionally promote homosexuality or publish material with the intention of promoting homosexuality, B, promote the teaching in any maintained school of the acceptability of homosexuality as a pretended family relationship. Pretty discriminatory. But Michael Howard, the future leader of the Conservative Party, when defending it in the House, would say this: we think that it is necessary. We do not think that it is damaging. It is the influence of local authorities on what goes on in schools that has given rise to much, if not most, of the public concern about the promotion of homosexuality by local authorities. And we wish to make it clear that the promotion of teaching in schools of the acceptability of homosexuality as a pretended family relationship is not to be permitted. As you probably are aware, various groups protested about the introduction of this act. There were concerns even from the Arts Council that it impacted expressions of freedom. And in Parliament, opponents openly labelled the act for what it is: discrimination against the LGBT community. However, on the 24th of March of 1988, the local government bill received royal assent and Section 28 came into force. The wording was clearly discriminatory, but what did it actually mean in practice? Well, the guidance issued by the Department of Education in May 1988 certainly gave mixed signals. On the one hand, it was said, Section 28 does not affect the activities of school governors, nor of teachers. It will not prevent the objective discussion of homosexuality in the classroom, nor the counselling of pupils concerned about their sexuality. That appears relatively clear. However, the next line then goes on, that where sex education is given, it should be given in such a manner as to encourage pupils to have due regard to moral considerations and the value of family life. It doesn't stop there. The guidance then goes on to make clear that the government's view is that there is, quote, no place in any school, in any circumstances for teaching which advocates homosexual behaviour, which presents it as the norm, or which encourages homosexual experimentation by pupils. So on one hand, the guidance seems to be saying, don't worry, it doesn't impact schools, it doesn't impact teachers directly, but on the other hand, makes very clear that the view of the government is that homosexuality shouldn't be taught in schools in anything other than an objective way, but with a good steer towards moral considerations, whatever that may mean. The Act itself has never had any judicial interpretation in England. It almost did in Scotland, but that case was pulled in 2000. And at the end, no cases were ever brought against a council. So we never got a definition of what it is to promote homosexuality. But what were teachers like Ash to make of that? Well, strictly speaking, as the guidance says, the Act doesn't refer to teachers, it impacted local authorities. In 1988, MRT McNair, writing at the University of Leeds, commented that although directed at local authorities, it did appear to imply, quote, some positive action on the part of a local authority rather than merely inaction, i.e., if a teacher within your education authority did something that would be counter to Section 28, could the council be held liable? He posited, for example, that teaching in schools on homosexual behaviour in ancient Greece, or indeed of King Edward II, could get a council into trouble if one were to interpret the word promote too widely. It certainly seems, regardless of what the letter of the law was, that the purpose that was expressed in Parliament for homosexuality not to be taught in schools was successful. By 1994, Debbie Epstein did a report in which she found that schools within schools, there has undoubtedly been an enormous amount of self-censorship, with some teachers believing that Section 28 does apply directly to their work and are therefore afraid of tackling issues of sexuality. She also offered that others have no doubt used it and welcomed it to legitimate their own homophobia. By 1997, the University of London had conducted a study of 307 schools randomly selected across England and Wales. They found that the vast majority of teachers were uncertain about the impact of Section 28, and over a quarter of those teachers believed that discussion of homosexuality in school, full stop, was illegal. Sadly, 82% of those schools reported that they had difficulties with homophobic bullying, and in most of those cases, the schools identified that teachers were reluctant to intervene because of concerns that they were not able to do so due to Section 28. So what was the effect? Well, the effect was that between 1988 until it was repealed in 2003, there was effectively no teaching in British schools. The curriculum fell behind, and developments that could have been made in the education of children on sexual health were lost. As McNair had predicted in 1988, given the drafting of Section 28, its direct effect on education may be limited, but the indirect effect will go deeper and last longer. How right he sadly was. Lord Whitty, sitting in the House of Lords in the Parliament side, would later describe it as probably one of the worst drafted clauses on our statute books. Even so, it wasn't repealed until 2003, by which time it in fact had effectively already been made redundant due to later legislation. It was a symbolic piece of homophobia, and it was smack bang at the end of the 1980s when the queer community most needed help from its government. It's a Sin casts a light not only on the emergence of AIDS in the 1980s, but the paradox of life that existed in that decade. Queer life had never been more free and visible, but that existed in a legislative framework that was still inherently discriminatory and with a government that was overtly homophobic. Of the three areas of legal history that I've invited you to consider tonight, all of them have echoes that impact us today. In the criminal arena, there are ongoing arguments, particularly with interventions from the Terence Higgins Trust, on the stigmatisation of HIV people and the fact that it remains a criminal offence in some circumstances to transmit it to another person. There are also issues about Section 71 of the Sexual Offences Act 2003, which deliberately targets sex in public toilets, which some academics have argued have now become a queer space. The Public Health Act of 1984, which we looked at in some depth, is even more perhaps important to every single person on this call, because at the moment it is the act that is being used to keep us at home under the coronavirus regulations, a point that Lord Sumption has queried whether or not that was a legitimate use of the act. Again, I urge you all to read his opinion on that. And last, the issue of schools, because as I've said, we lost time developing a curriculum over 2 decades. We are now well behind in developing our curriculum in this country on LGBT rights in schools. So that to the extent that when this government tried to introduce it, we find protests outside of the gates and some parents unwilling to let their children attend. There's lots of interesting reading. There's lots of interesting issues for you to explore, especially as students of the law. I'd really urge you all to read this book, which is called United Queerdom by Dan Glass, which is a great introduction to queer rights in England. But I would urge you all to read up and to act up. And thank you for listening.
Thank you so much, Simon, for that erudite talk in relation to the 1980s. From both speakers, we've had an insight into how far we've come and how far the journey is that we have to go upon. And so I'm thankful to both of them, but also thank you for listening. There have been a few questions. I'm not sure how much time we have, but one of them from Edis, I'd like to be him to ask if he wouldn't mind himself.
Not a problem. Can everyone hear me? Okay, this is a question for Stephen. So I've picked up on a couple of points, and just before I ask this question, can I just double check something with you? are you familiar with the Smug versus Lively case?
No, I am not.
Okay, not a problem. I can go over the brief points on this. So you've mentioned that one of the key sort of things you want to see is essentially money and businesses with the economic ability to push the debate to decriminalize LGBTQ sort of oppression that occurs in these particular countries. The reason I bring up the case of Smug versus Lively is my question to you is, what do we do about the opposition to that? So from the other side, where people are using their economic influence to sort of in the modern century criminalize in countries that may necessarily not have had those laws to begin with. A key example of this being Uganda, where Scott Lively, who is both a solicitor and a church pastor for one of the prominent churches within the US, essentially came to Uganda to criminalize same-sex marriage and homosexuality within the country, using his money, his influence, and also his authority within the evangelical side to sort of bring those restrictions upon the country. And what as people, what as a country, and what as sort of companies, what can they do to sort of combat that? I would say combat the yin to the yang in some aspects when it comes to sort of money being on the wrong side of the political spectrum.
So I'm glad that I don't know the case, but I'm glad that I have an answer. When I watched the movie with my mum, actually, last weekend, called The Abominable Crime, that is a documentary that spotlights the gay rights activist Maurice Tomlinson, when he received the award, the David Kato Award, which was marking the murder of David Kato, who was a Ugandan LGBT rights activist, he said in that speech that his mother told him that when she was growing up, she recalled a time where everyone in the community knew at least one gay person, but it was dealt with as a matter of privacy. And then what he witnessed was American money flowing down to Jamaica to galvanize a particular agenda against the LGBT community, which has resulted in this, what I can only describe as an extremist perspective against LGBT rights. And frankly, if those churches were operating within the UK government would look into whether or not they are supporting hate crime. And so now that we have the Democrats in power in America, that's the kind of thing that Kamala Harris and Biden, it should be put on their agenda as where the church's money is flowing. The problematic element of that in an American context is that the church has a particular space in the political discussion that it doesn't have in the UK. And so that's what my solution would be on a political and a religious level. Does that answer your question?
Thank you. The reason I brought up that particular case, I touched on that point to begin with, is the idea of other countries, sort of individuals influencing sort of outside of their jurisdiction. Because the Smug versus Lively case, the court opinion essentially said what he was doing was lessening the rights of Ugandan people by promoting anti-LGBTQ legislation in the country. But because he was out of the jurisdiction of the US for most of his promotion, even though the court in its opinion criticized his behavior, formal sort of legal action couldn't take place.
I wonder if it's something that could be referred to the ICC in The Hague. If it's an international crime overall, then it might be that someone needs to take up that case.
Possibly. The only problem is it's been used on the Alien Tort Statute, which usually sort of gets around that issue. And I mean, this is as recent as 2019, the actual case has sort of come to a conclusion. So it's sort of post-COVID when the situation sort of comes back to prominence, we'll probably get an answer in terms of, is there another means in which the sort of courts can look at this issue in terms of jurisdiction, but also sort of, because let's be honest, companies have a transnational effect, and that sometimes is overlooked when it comes to sort of the national situation in terms of where blame can be attributed.
It's really interesting. I mean, if it was a proceeds of crime in a UK context, then the UK government would go about freezing assets. And if there is similar legislation that could be put together specific to this particular crime, then I think some multifaceted thinking would need to be addressed. That's my answer in an American context. But ultimately, it's about people in America not funding views that ultimately they don't support.
Thank you. Sorry, I had a bit of a weird question on that one.
No, it's a good question. Thank you.
I'm going to ask Simon a question now from Victoria. It's about the long-term and wider impact of the Wolfenden report and what that impact has been in terms of supporting the conservatism stroke private interference framework to be the legislative way about things. For instance, considering how the wording of the 1967 Act aligns with the wording of the Abortion Act also from the same year, or the case law that has been referred to by Simon. So, Simon, what are the longer term and wider implications?
Thanks, Sam. So for those of you who aren't familiar with the Wolfenden report, it came out in 1957, and it was a report that came at the end of a committee that had run for some time with a view to reviewing a number of issues, but one of the principal ones was the state of the law in terms of acts of same sex. The report in itself is largely deemed relatively conservative in that, for example, at the committee stage, to protect the ladies that may be watching the committee, gay men were referred to as, I think it was Harkleys or Harleys, to protect them from having to listen to the word gay man or homosexual man. The report itself obviously was a very important document for gay rights because it is credited with leading to the 1967 Act. But there are aspects about it which, as Victoria's question indicates, are conservative. I'm not particularly au fait with the link with the Abortion Act, but what I can say is some of the examples I've given in terms of the age of consent was different, but there are other aspects of it as well. You have to remember that in order to get anything through, there had to be an air of respectability. And so the committee only spoke, I think it was to 4 gay men in total, of all the witnesses that it called over the time that it was running. And those men were from very select parts of society. They were not working class, for example. Most of them tend to be pretty well-off, well-connected men. They were considered respectable. And from that regard, the way that the law was shaped and the recommendations that the committee gave were always going to be through a prism of a select group of society. So in terms of its role now, from a same-sex perspective, it has very little importance, but it did dominate and was part of the reason why it took so long to have an equality between straight and same-sex relations over a large number of decades. But it's very easy to criticise it with hindsight. I have been told off for that before by somebody who is much older than me, because if you were around at the time, it was a huge step forward. So yes, as with many things, it probably didn't go as far as it could have done, and it did go as far as I would like looking back. But it did. It is something that people at the time that it did mean a lot. And what was the disgraceful part was that from it coming out in 1957, its recommendations weren't in fact enacted for another decade. I hope that's answered the question in a roundabout way.
I'm going to align a couple of questions, and this is going to be the last question, but it's really for both of you. And it's about influence. How do we influence either politicians in an environment where LGBTQ plus rights are not promoted or indeed discriminated against? How do we effect change on a governmental or international level? Are we to influence our trading partners by making it prerequisite of trading arrangements that they adhere to certain standards in relation to their public life and their public attitude towards the rights of gay, lesbian, bisexual, transgender, queer people. That's, as I say, eliding two questions, one from Jack, one from Andrew, who in Andrew's case particularly points to the difficulties of faced in South Africa and also the Kenyan courts in relation to sexual orientation, and how one deals with the anomaly of a huge continent where there are endemic religious and social objections to gay rights. So I hope both of you have something to offer in relation to those two elided questions, as I say.
Yes, Simon, do you want to go first?
Well, I'm conscious that the international aspect would be treading a little bit on Stephen's toes, but I would say in terms of the specific question on Poland, I think a lot of people have been watching that story growing with interest. The idea of road signs going up that say you are now entering an LGBT-free zone is quite shocking. In my view, and you may or may not pick up on the extent to which I'm a slight Eurosceptic, I do think that there's more that could be done to put economic sanctions on Poland. I understand that its neighbouring countries are in fact doing that and have said that there are various funds that they will not be supporting Poland with. And that is sad in the sense that the areas that will be hit are the poorer areas of a country that isn't overly well off in the first place. But I don't know that beyond economic sanctions, we don't have too much in terms of bashing them with. But I think in terms of from a domestic perspective, my view at the moment, and this is the point that the forum, is that one of the best things that we can do is be visible and to show whatever government comes in that we're here, we've got these rights and they're not going away. I hope in some respects the two talks that you've heard tonight show you not just the fight that people have to make to get rights, but the fragility of them once they're obtained. Nobody would have believed if you'd asked us all 2 years ago, does the government have the power to stop you seeing a family member for months on end? I think any legal student and probably a lot of constitutional lawyers would have laughed, but it's happened. And for those reasons, I think continuing to support groups like Stonewall with their works internationally, continuing to work with charities in this country and continuing to work as a lawyer, because it doesn't matter what area you're in, there are areas of LGBT rights that you can further. They may not be directly linked, but there are all sorts of areas that you will be surprised. It's been my privilege in my short career to date to have represented gay people in cases where they felt that the justice system was not there for them. And that's a big thing that we can do as lawyers. So I'm sorry if that's a bit of a cop-out from some of the specific areas, but those are my thoughts for what they're worth.
Thank you, Simon. That gave me a chance to jot down a few things as well. What I want to say as someone who comes from Jamaica is that there is a strong sense that when there is an effort from the West to reform anti-gay laws, it's seen as being patronizing and an attempt to go back to colonial times. And I think a real intellectual discussion needs to be had, reminding people from the Commonwealth that actually the laws that they're seeking to hold on to are laws from Westminster in the first place. I agree that money does talk. And for instance, before the Stonewall Index became a thing, that became a thing because there were investment banks who said to law firms, well, what is your position on LGBT employees? And so they scrambled around, forming networks within their organizations and taking LGBT rights of their employees seriously. So money does talk. But what I would say is that within certain jurisdictions, Maurice Tomlinson in Jamaica has certainly said that whilst some people in the government want there to be people who are educated and articulate speaking about LGBT rights, those jurisdictions have to provide the security for those activists to be able to have that discussion. Maurice Tomlinson doesn't want to be murdered as Brian Williamson was, because what that means is that whilst he's there trying to change the narrative, what you have is people being murdered. And then the only narrative you have of LGBT people in Kingston is that they're gully queens, which isn't helpful. But when we enjoy the rights that we do in, say, the UK, we can't be complacent. So we have to continue having discussions with people from other jurisdictions, and Middle Temple is ripe in terms of the relationships we have with bar associations all over the world to have those really important discussions. And when we are having discussions with those other governments about why it's important and in their interest to decriminalize homosexuality, you can point to the evidence about how their healthcare bills will get cheaper and how their brain drain and resources will be supported by basically not losing talent like Simon and Sam King, and also that they will be spending resources on their police force on actual real crimes. In Jamaica, with people being murdered in the way they are, the police don't need to be wasting time raiding the house of gay couples. They've got other things to be doing. And what I would say is that having discussions with people in the EU, so in Poland, for instance, some Polish citizens were sent to Auschwitz, and you can draw parallels between the discrimination suffered by Polish citizens, the Jewish community, as part of the story of the discrimination that LGBT people suffer now. It was Polish citizens, Jewish citizens who were all sent to Auschwitz, and LGBT citizens. So, and reminding people, for instance, in South Africa, that they are very clear where they stand on apartheid. Why can't they see the parallels between the struggles of the Black community as being coherent with the struggles of the LGBT community? And what I would say as a challenge to what I've just said is that when you're talking to people that are struggling with, for instance, in Myanmar, Burma, for basic socioeconomic political rights, for democratic rights, when you talk to them about LGBT rights, as I did when I was in Burma last February, they say to me, Stephen, that sounds great, but dude, I'm trying to put food on my table and have a job. And we're in that hierarchy of rights, we have to be able to persuade them that when what we take as basic human rights, to them, those socioeconomic rights are a luxury. They are a luxury that we have in the West. And when we are looking at some of the fundamental economic challenges that they are dealing with on a day-to-day basis, we cannot forget that what we are discussing with them effectively is seen as a luxury for Western LGBT people. And if there is a way of aligning their interests in improving their health outcomes, their economic outcomes, and their democratic outcomes, then that is a way of making the argument a cogent one in terms of bringing them along with where we hope they would be.
Thank you very much, Stephen and Simon. As I say, they were extremely interesting talks. I think you've probably seen the comments coming up throughout the discussion to indicate people's interests. And we hope that when we have the next LGBTQ+ forums talk, that you'll all join us again. So thank you very much, and have a good evening.